Welcome to Emend Healthcare. As a behavioral health technician, you are the face of this facility and the first point of contact for all the people relying on us. You spend more time interacting directly with clients than anyone else on staff. It is entirely natural to want to be friendly and build rapport. However, crossing the line from a supportive conversation into sharing private information carries severe legal consequences. You likely already know the basics of standard HIPAA regulations. Federal law requires us to fiercely protect basic identifiers, a client's name, their medical chart, and any information that connects them to their healthcare. This diagram shows how standard HIPAA rules intersect with a stricter federal law known as 42 CFR Part 2. Because we treat substance use disorders, Part 2 applies an even tighter, expanding lock on our data. A person is in our building, receiving treatment, is strictly protected information. Guarding a client's presence is the absolute foundation of your daily practice. When clients trust that their privacy is airtight, they feel safe enough to participate openly in a trauma-informed environment. Let's apply these rules to the floor. You are stationed at the front desk. The phone rings, and a frantic caller demands to know if their son was admitted to our program. You refuse to confirm or deny that anyone is here. First, check the system for a valid release of information, or ROI. If there is no ROI specifically naming that caller, you simply offer to take a general message and end the inquiry. Holding that firm line on the phone executes the 42 CFR Part 2 mandate perfectly. You protect the client from external exposure without escalating the caller's anxiety. Later in your shift, you walk into a residential common area. A coworker approaches you and starts venting about a difficult interaction, using a client's full name. Other clients are sitting right nearby. You gently interrupt your coworker, suggest you both step into a private office, and close the door before continuing the handoff. This funnel illustrates the minimum necessary standard. Even behind closed doors, a large volume of information is filtered down, and you share only the specific, essential details the next shift needs to keep the client safe. Correcting a coworker in the moment stops a privacy leak before it happens. Overhearing staff gossip about another resident breaks a client's trust and triggers trauma responses. Keeping care discussions private maintains the integrity of the therapeutic environment for everyone. Sometimes the pressure arrives in person. An intimidating attorney approaches you at the facility doors, aggressively waving a legal document and demanding immediate access to a client's records. No matter how forcefully they demand answers, a subpoena or a search warrant alone is never sufficient to release client information. This comparison chart outlines the exact legal distinction. A standard subpoena gets a red X. The only document that authorizes the release of substance use disorder records is a court order explicitly signed by a judge. You never play lawyer. You immediately escalate all legal requests and any suspected privacy breaches straight up the chain to the facility director. If you work in an outpatient setting, like a PHP or IOP program, the risks move to physical and digital touchpoints. Whenever you step away from a workstation, you must lock the computer screen immediately. Physical documents require the same strict handling. You must always shield sign-in sheets from the view of spouses or visitors waiting in the lobby area. When executing digital communication, keep appointment reminders entirely generic. Voicemails and text messages must never mention identifying terms like rehab or treatment. Rigorously maintaining these physical and digital boundaries proves to clients that their vulnerability is protected at every level of care. That constant attention to detail establishes deep clinical trust. As your shift concludes, keep in mind that federal laws act as a baseline. Your local state laws apply a final, stricter layer of privacy regulation that you must follow. As this map of California shows, we operate under DHCS Title IX regulations and add the CMIA and LPS rules as strict pillars governing medical and mental health data. Let's recap your core rules. Rule 1. If it identifies a client, protect it. Rule 2. Never confirm a client's presence without a valid ROI. Rule 3. Always share only the minimum necessary information required for the task. Rule 4. Escalate all legal issues and suspected breaches immediately. Rule 5. Always apply the strictest applicable regulatory standard to your work. Mastering this complex web of privacy rules frees our clients to focus entirely on their recovery, completely safe from the fear of community exposure. This training supports design and audit readiness. It is not legal advice. Specific citations must be verified against the current Emend Policies and Procedures Manual and current standards before survey.